Welcome to Arisapedia.com's presentation of Stephen Forbes' Participant Loan Failures, Self-Correction versus VCP Correction. My name is Maureen Pesic and I will be facilitating this webinar. Stephen Forbes is an ERISA attorney and educator with 32 years of experience practicing and teaching in the retirement plan area. Stephen recently returned from a 3-year sabbatical where he presided over a mission for his church. Previously, Mr. Forbes was Vice President of SunGard Relias in Education. At SunGard, he taught seminars, conferences, and web seminars on retirement plan compliance, design, and correction. He also helped draft Qualified Plan 403B, 457B, 409A, and IRA documents, and was the author of other publications. Stephen was also a tax law specialist at the National Office of the Internal Revenue Service, Employee Plans Division. After receiving his bachelor degree, he graduated from Willamette College of Law. He then went on to obtain a Master's of Law degree in taxation from the George Washington Law Center. Tim McCutcheon is the publisher of Arisapedia.com and president of Vermont Compliant Labs, LLC. Tim was also the founder of ftwilliam.com, the most innovative document and government forms provider in the industry. He wrote the first web-based 5500 forms package and introduced the first retirement plan document e-sign system. Prior to founding Arisapedia.com and ftwilliam.com, Tim's law practice included counseling TPAs, financial service companies, and other benefit service providers regarding qualified plan, product design, and compliance. Tim is a member of the IRS Great Lakes TEGE Council and a former member of the Information Reporting Program Advisory Committee of the IRS. He received his JD cum laude from the University of Wisconsin in Madison, and he's also a CPA and holds an MBA from the Kellogg School of Management at Northwestern University. Excited to have Stephen and Tim with us this afternoon. As I said, my name is Maureen Pesic and I will be facilitating this webinar. Also on the webinar is Joanne Pacina, who will be monitoring the question board. A few housekeeping items before we begin. All of the attendees' lines are muted, so if you would like to ask a question, you can type it in the GoToWebinar dashboard in the questions section. Joanne will help Stephen to get to as many as he can during the presentation, but all of the questions and answers will be posted on the Arisapedia.com webpage in a few days. A copy of the slides can be downloaded from the GoToWebinar dashboard in the handout section, and the slides are also available on Arisapedia.com. This webinar is being recorded, and a copy of the complete webinar will be available on Arisapedia.com. Also, CE credits will be sent to the email address you registered with. ASPA and NIPA credits will be mailed in a few days. IRPA credits take a little longer, so please be patient and be sure to check your spam folder. Any questions, email us at support@arisapedia.com. And now, without further ado, here's Stephen and Tim.
Hello, everyone. Today, this is Stephen Forbes, and it's good to be back with all of you. It's I hope in the near future I'm able to reacquaint myself with old friends and make some new friends. Anyway, today we're going to talk about loans. Loans is always a favorite topic of mine. There always seems to be a lot of questions, a lot of issues, and a lot of problems with respect to it. Of course, we're also going to be talking about how we correct these problems and do it in the most efficient and effective manner. So the title of today's program is Loan Failures, Self-Correction versus Voluntary Correction, the Voluntary Correction Program. It's always a kind of a debate as to how we go about correcting these things, whether we just go ahead and self-correct it or we do the Voluntary Correction Program. So we're going to first address some of the typical loan failures that are governed by the Internal Revenue Code. These are the plan sponsor fails to withhold the loan repayments, or the loan is in excess of the plan limits, or the loan exceeds the duration requirements, the 5-year requirement, or the plan document doesn't even provide for participant loans, or the participant fails to actually complete the necessary loan documents. We'll also address some of those governed under ERISA, the Department of Labor. That is, the most common one is failure to deposit the loan repayments into the plan on a timely basis. This is governed under the same regulations that govern the deposit of 401k deferrals and after-tax contributions. We'll also address the use of an interest rate other than a fair market interest rate, or a loan that failed to comply with the plan documents for the amount, duration, or level amortization requirements, and that the plan document is incomplete. Okay, let's address the most common one, which is failure to withhold loan repayments. This is by far the most common one. One of the unfortunate realities of loans is that it puts the plan in the position of being, a debtor, and or excuse me, a lender in this case, and it has to collect the payments. Now, most plans, in order to make loan administration more efficient, use payroll deduction, and I'm a strong proponent of payroll deduction. It makes certain that the loans are paid, and it keeps the administration of the loans. It minimizes the costs and the hassles related to it. Now, just as a sidebar, I suspect if I talk to most administrators, they'd just as soon not have participant loans. I remember at the beginning of my history in working with retirement plans, I used to try to talk employers out of having participant loans. And initially I was successful, and then eventually most of them would come back and say, listen, we need to add this feature to the plan. So I just came to expect that most plans will want participant loans. It's just a necessary feature. A lot of employers think that without it, that the participants won't participate as much in the 401k. Whether that's correct or not remains to be seen. But again, getting back to it, the most common failure is the failure of the plan or the employer to withhold the loan payments. And so that means that the payments are not made on a timely basis. Now, since most plans provide for payroll deduction, oftentimes that complicates things just a little bit more. It adds more parties to the administration. You now have a payroll provider that oftentimes is in charge of withholding those. You've got a trustee involved, and of course you've got the employer and the participants. Now, if you miss a payment, whether it's through payroll deduction or otherwise, then the regulation period, and if the payments are made up within the grace period, then it's a no harm, no foul situation. The maximum grace period provided under the regulations is that a missed payment must be made up by the last day of the following plan year quarter. And of course, if it's not, then obviously you've got a taxation issue there. Now, the plan document or its loan policy can provide for a shorter grace period. What you should do is look to the loan policy to determine exactly what the grace period is. Most plans are using the maximum grace period. It just gives them a greater amount of time in which to correct any missed payments. Unfortunately, despite the fact that you have this grace period, the participant frequently fails to make up the missed payments during the grace period, and therefore the consequence under the statute is that the entire plan loan, not just the missed payments, the entire unpaid loan plus any accrued interest are treated as a deemed distribution, meaning that they're taxable to the participant. Furthermore, if the participant is not 59 and a half, then the individual is subject to the additional premature distribution tax. Now, furthermore, to make this even more difficult, unless the participant incurs a distributable event, such as termination of employment, the participant continues to have the responsibility to repay the participant loan, although typically they do not. But if a participant pays a loan or pays it after it's been treated as a deemed distribution, then you are creating a basis in the account of the participant. In other words, after-tax money with respect to it. Now, failure to pay a participant loan is, or to make the loan payments on a timely basis, is really more of a taxation issue than it is a qualification issue. And so initially, when the IRS came out with their correction program, they did not provide for any correction mechanism for participant loans because, as I mentioned, it was a tax issue and not a qualification issue. And in the EPCRS, the IRS's correction procedure, is primarily dealing with qualification issues. But because the failure is so common and because it causes such significant consequences on the participants, who are frequently non-highly compensated, the IRS decided to establish a correction method whereby employers can correct this and help avoid the tax consequences that fall on the participant. Many of you have probably been to seminars where I've talked about the correction procedures. As many of you know, when the IRS first started thinking about the correction procedure, I was back with the IRS, and I was on the initial task force that started putting the framework of the predecessor to EPCRS together. And I can recall the issue with respect to loans came up, but since we didn't even have any regs at the time, we decided not to include it. It's been a blessing that they have now included it. Now, the causes of the failure of loan payments are frequent. Here are some of the common ones. The payroll company fails to withhold. Either they didn't get the communication or they failed to implement the communication. It can occur with a change of payroll company or change of plan trustee. Sometimes it happens with mergers and acquisitions, and it's just the transition from one payroll provider to another or from one institution to another is very difficult, and it's easy for something to slip through the cracks. And since there's so many loans and you got payroll is a monthly or weekly or bi-weekly basis, there's just a lot of administration that goes along with loans. Now, although participants are in the best position to identify the failure, in other words, they could go to the employer and say, listen, you haven't withheld the payments, and then the employer could quickly rectify that and hopefully do it within the grace period and therefore avoid any of the consequences. But the employees, unfortunately, rarely notify the employer. They just, they just are kind of hoping against hope that maybe maybe they don't have to pay it, or it's put off as long as possible. Consequently, the failure continues beyond the grace period, and therefore we can't correct it under the regulatory method. So, as I mentioned, the IRS came up with a correction method under the Voluntary Compliance Program. What an employer can do is they can file an application under VCP to resolve this failure. Now, if they file it under VCP, the program gives them two choices. They can either completely avoid the deemed distribution to the participant and the premature distribution tax, or they can delay the deemed distribution to the year of the correction as opposed to the year in which it occurred, which is probably the previous year or maybe even 2 years previous to that. Most people who decide to go under VCP go with the first option. They want to eliminate the deemed distribution altogether and avoid any tax consequences on the participants. That just makes participants very unhappy to come up with a fairly significant tax bill. Now, what are the VCP correction requirements? In order to obtain relief, in other words, not have the loan treated as a deemed distribution and not being subject to the premature distribution tax, the participant must make a lump sum. One option is to make a lump sum payment of the missed payments. In other words, whatever those are, those total those up, and the employee makes up the missed payments. That's rarely done because the participant usually doesn't have those type of funds available to him or her. A second option is to reamortize the loan over the outstanding loan, including any of the accrued interest, over what is left of the 5-year repayment period. You do not get a new 5-year repayment period. It's over what's left. The third option is kind of a hybrid. It's a combination of 1 and 2, or they make up maybe some of the missed payments and then they reamortize the balance over there. But by and large, the most common one, if they file under this, is number 2. They reamortize it over the remaining balance. Now, if the original loan term was less than 5 years, they can spread it out over the entire 5-year period. In other words, they can use the entire 5-year period for the reamortization. Now, as part of this correction, there was also the fact that, there was no interest being paid on these, or no earnings being generated with respect to these missed payments. In other words, they were not inside the trust. So the VCP procedure also requires the employer make up the missed interest payments on the fact that the missed payments were not within the trust. Now, this is, and the rate for that is a rate equal to the greater of the plan loan interest rate or the rate of return for the plan. Usually this amount is minimal. It's not that expensive. It just probably takes more time to calculate it than they would like, but nevertheless, that is one of the requirements of VCP. Let me see if I can illustrate this with an example. So Ed obtains a 5-year loan for $15,000 from the plan on January of 2017, and monthly payments are going to be withheld from his wages at $280 a month. Now, the employer, for one reason or another, failed to implement the payroll withholding, and of course the employee didn't notify the employer. Was hoping he would be able to avoid it as long as possible. Anyway, after 8 months, the administrator discovered that they had missed 8 payments. So they're well beyond the grace period. Now, they can correct this under VCP by filing, reamortizing the loan over the remaining 4 years and 4 months. So there's so that the loan plus the accrued interest rate, or Ed can make a lump sum payment of $2,240. That's the 8 missed payments. They can continue on the loan, or they can have a combination of 1 and 2, where the employee, Ed, makes up part of the missed payments, and then they reamortize the rest. In addition, the employer would need to make a payment of interest on the accumulated payments that were late with respect to it. So that's how you would correct it under VCP. Now, the deadline for correcting under VCP is, of course, 5 years. In other words, you can't resolve this under VCP if the 5-year period is already expired. One thing to encourage employers to file under VCP, the IRS has streamlined the procedures. They now have forms check boxes and fill in the blank boxes that you can use to streamline it. There's a Schedule 5. Actually, it's a particular form. I'll show it to you in just a few minutes. And they've also provided a reduced filing fee for these loan failures. Now, if the only failure that the plan is filing for under VCP is a loan failure, the filing fees are dependent on the number of participants with loan failures. This is a change. It used to be on the, it used to be based on, I think, the number of participants you had in the plan. But anyway, it is now based on the number of participants with loan failures. So if you have 13 or fewer, then the compliance fee is only $300. That's what you pay the IRS with your VCP application. And of course, increases depending on the number of participants, loan failures. So this is helpful for a medium or large size. Maybe they change their payroll administrator and they have a large number of these loans, and they can resolve these and avoid significant unhappy participants. Now, I mentioned there's a streamlined procedure. There's a form that you would include with your VCP application for loan failures. This is used to be referred to as this Schedule 5. It's now incorporated in Form 14568-E. Now, this is not the entire form. This is just an excerpt of the form for that, and it has loan failures on there, and as you can see, you kind of check the box. You'll notice here, if you're looking under on this particular screen, that if an affected participant is either a key employee or an owner employee, then there is a slightly different procedure. If you're trying to avoid the deemed distribution, then in large part you're going to have to request that without using this particular form, and you're going to have to do it in some form of narrative attached to your application. Usually that the service has been pretty good about accepting it, even for key employees and owner employees. And as you can see, you identify which approach you're going to use for purposes of correction, whether you're going to the employee is going to make a lump sum payment of the missed payments, or they're going to re-amortize it over the remaining period. You indicate the interest rate that you're going to use, and you also indicate who is going to make up the missed interest with respect to the failed payments. Now, that's how you correct it under VCP. And the IRS is trying to make it as attractive as possible by having a check the box form and a lower sanction fee or user fee for purposes of the correction. But oftentimes, in particular for small employers, the employer is saying, you know what, it's not the user fee so much that we would have to pay. It's we need to hire a professional to file it for us and go through the process of doing it, and it just ends up being expensive. And oftentimes they're not really that excited about it because they feel that the participant is partially to blame because the participant never alerted them as to the fact that there was a potential failure. In other words, they weren't withholding, and they figured the participant had to have known that this amount wasn't being withheld. So the question is, can we just quote unquote self-correction? Now, in the procedure, they don't specifically talk about a methodology for an employer to self-correct, but the IRS has acknowledged numerous times that obviously they can just treat it as a deemed distribution, and the participant pays the taxes and pays the premature distribution tax. So that is an option that is still available. Now, it's important to note that you treat it as a deemed distribution in the year in which the failure occurred. So if it's last year, you're going to have to file the 1099-R for last year or the previous year, and it means the participant may not only owe the taxes and the premature distribution tax, but may owe some additional penalty for late payment of taxes. So you just have to take that into consideration, and you've got an unhappy participants.
Stephen, would you like
so
to take
as I mentioned, sure,
Stephen,
go ahead.
Let me, I just was going to pop in and see, there's a couple questions that have come up. We're actually getting several, but I thought a few of these were pretty good. Back on the accrued interest that's paid, one of the questions is, are you saying that accrued interest is paid to the plan twice, once with the re-amortization over the remaining period of time to pay, and again by the employer?
The answer is yes. There's interest on the loan that is due, but the fact that, you know, it's the old issue of time value of money. In other words, that you didn't make the $280 payment 8 months ago, there's effectively interest on that also needs to be paid, and the VCP procedure indicates that the employer is responsible for paying that. So yes. In other words, if that $280 payment were in there 8 months ago, it would have been theoretically generating earnings. And so the IRS says that there's some interest due on that. It's usually very modest, and it often takes more time to calculate it than it's worth, but nevertheless, the IRS indicates that you need to pay that. Okay? Hopefully that answers it. So the answer is yes.
Great.
Do you have another question there?
Yeah, we actually have several, but let me come to another one here. Is to clarify the original question of the maximum cure period. Can it extend to 5 years plus the quarter after the quarter the payment was first delinquent?
That is a great question, and I've been on panels where that has been discussed. In other words, do you have can we effectively extend the 5 years beyond because of the grace period on top of it? My feeling, and I've heard people disagree with that, is that the IRS tends to take a very strict view. It's 5 years, and then you can't go beyond the 5 years. Now, I don't know how strictly the IRS would enforce that, but I think in practice, I would just, if I were going to re-amortize it, I would only re-amortize it over what's left of the original 5-year period.
Great, thank you.
Okay. Hopefully that answers the question. Okay. Let me review these again. I think I already said these, but just for review, for steps for self-correction, if you decide the plan would just treat the loan as a deemed distribution, and the participant would be subject to the tax and the premature distribution tax. When you self-correct, and I would generally document this. It's generally good to put it in a file, your steps to avoid this failure from recurring. So, okay, we're going to take in the future, we're going to review this or whatever. And arguably on a self-correction, the employer, like we just discussed, would also be responsible for depositing interest on the payments which were missed. And then of course, the employee would continue to remain liable for the repayment of principal and interest on the defaulted loan. Oftentimes they don't pay, but they still remain liable.
Stephen,
yes.
Tim, first off, welcome back. It's great to have you back. This has been a very popular session. We've got more than 1,100 people on the line, so I think that's a testament to what people think of you. So welcome back.
Thank you.
A quick question on the previous slide. We often get questions on our Ask line where the fact pattern is participant A has defaulted on 7 loans and wants to take another one. So on your second bullet point, can a plan be qualified if it lets people take out loans where they know they're not going to pay them back?
Well, let me break that into essentially two parts. First of all, I think the first question I would address is, can a plan make a loan to a participant who has an outstanding defaulted loan? And although I think it's unwise, the answer is apparently yes. I mean, the regulations talk about situations where that might occur. But I also think in your loan policy, you could institute requirements that you're not going to issue a loan to someone who has an outstanding defaulted loan, and therefore just kind of stop that. I think you'd be foolish to be continuing a loan to somebody who's continuing to default. Your second question is, can a plan still be qualified if they know that they're not going to pay it? Now, that's a question of being able to prove that. But if the IRS or Department of Labor were able to prove that you issued a loan to someone you knew had no intention of repaying that, then that would be an improper loan. And it potentially could raise not only the tax questions, but also qualification issues that the IRS could say, well, that's just an improper distribution. It's not authorized. And so if they had no, and supposedly they might be able to establish that if it were like an owner. I've seen them do that. I can remember at the IRS where owners were taking out loans and really had no intention of repaying those loans, and the IRS threatened disqualification. Does that answer your question, Tim?
Yes. Thank you.
Okay. Now, sometimes when if a plan just quote unquote self-corrects, just says, you know what, we're not going to file under VCP, we're just going to treat it as a deemed distribution. Sometimes the employer steps in if they feel that they're partially at fault or substantially at fault, and may help the employee with their tax obligation. They're not legally obligated, but they may feel morally obligated. In that case, that would be, they could do that, but the IRS would consider whatever additional amounts that they provided to the employee as additional wages subject to withholding with respect to it. Now, what about preventative measures that you might take? Now, since the participant is in the best position to identify and avoid these failures, sometimes it's important to incorporate not only to your loan policy and your loan note, and maybe even your communications with the employee, that, listen, we have this loan program, but participant, you're in charge of making certain that the payments are withheld because you're going to bear the tax consequences. And so you would tell them, listen, if they're not withheld from your paycheck, you're to tell us you need to step forward and the employer so that we can correct it within the grace period. And if you don't, then you're going to bear the tax consequences. This is just kind of a warning to the participant, and it may help these failures from occurring. You place the burden, which is where the statute places the burden. Now, who is responsible? Let's say the employer fails to withhold the loan payments. This question comes up. There is actually, it's not as recent, and it's over 10 years old now, but there's a tax court case that sheds some light on this. And when an employer fails to withhold the loan payment, it raises two issues: the tax consequences to the participant and whether the employer has any liability with respect to. Now, the case really focused on the first issue, but it does seem to suggest an answer to the second question. In this case, a participant obtained a loan that was supposed to be repaid through payroll deduction. A few days after he took the loan, he transferred to another division within the company. Because of the transfer, the loan payments were not withheld. Now, prior to the end of the grace period, they sent him a letter indicating, listen, you got to make up these missed payments, otherwise it's going to be a deemed distribution. Unfortunately, they had incomplete address information, and it may or may not have arrived there. The loan defaulted. They treat it as a deemed distribution, issued a 1099-R. The IRS later assessed the taxes on the deemed distribution and the premature distribution tax. The participant argued that he shouldn't be taxable because he never got his quarterly benefit statements, he never got the letter notifying him of the delinquent payments or the 1099-R. The court, interestingly enough, decided that even if they accepted all of the participants' arguments, apparently they weren't necessarily convinced that all of them were accurate, but the participant nonetheless failed to comply with the statutory requirements, and they were not made up within the grace period, and therefore the participant was taxable. He was responsible. And so this kind of illustrates the strict interpretation of the loan rules. The IRS is basically unwilling to accept any excuses or retroactive correction other than, the VCP if it goes beyond the grace periods. In other words, if the loan payments have not been withheld, irrespective of who's at fault, the participant has not made the loan payments within the time period or the grace period, and the participant is taxable. So it's it again illustrates the strict view that the IRS and even the courts have with respect to the loan payments. So let's shift gears to another error that occurs. We got correcting a loan in excess of the limits. In other words, you've got a loan limit. It's lesser of $50,000 or 50% of the vested account balance. Now, these are fairly straightforward requirements, and most people can calculate these accurately, so that it doesn't happen all that frequently, but it does seem to occur when they're second or third, or as Tim was suggesting, they had a plan sometimes with even 6, 7 loans. One time I had someone call me, and they had a participant who had like 41 or 42 outstanding loans. Why they would allow them to have that many is beyond me, but or they refinance the loans, and there's very strict refinancing rules. So assuming that the loan payments were made within the proper schedule, then the correction under VCP is to they can assuming that the loan payments were made in accordance with the amortization in one of several ways. They can solely to reduce the portion of loan that did not exceed the loan. In other words, they just take the payments and applying to the proper amount of the loan, and then of course then the participant would pay off the amount which was in excess of the loan limits. So the participant needs to pay off the amount in excess of the loan limits, and plus the interest on that particular portion. Or number 2, they could apply they would still have to pay the excess amount off, but they could pay the interest on first to the excess loan amount, and then the amount to the amount within the limitation, the proper amount of the loan. And therefore the corrective payment would equal the excess loan amount, because the interest would have been that was paid would have been used to apply to that. Or they could do a combination of one or 2. So that's a correction with respect to this. Now, after the corrective payment has been made, the plan would reamortize the remaining loan over the remaining period. Now, if they did this, of course, they wouldn't have to treat the loan as a deemed distribution, or the amount which exceeded the limits as a deemed distribution. Let me see if I can give an example of this. So in January, Kathy obtained a $22,000 loan, made 5 monthly payments. Now, they discovered, because of the refinancing rules, that Kathy's loan exceeded her limit by $2,000. So she's going to need to make she can correct the failure by making a lump sum payment of $2,000 plus interest, and then they just re-amortize the remaining portion over what's left of the 5-year period. Or alternatively, they can take the loan payments and they can use part of it to pay the interest on the excess amount on the $2,000, and the remaining amount to pay the interest on the proper amount of the loan. And then she would just make a corrective payment to the plan of $2,000, or they can do a combination of the two. In each case, they would, of course, have to re-amortize the loan. Okay, this one doesn't occur that much. Loan exceeds the duration requirement, 5 years except for a home loan. It's pretty straightforward, so as I mentioned, it's rarely violated. If it occurs, it's because it has the wrong starting point. The loan, according to the IRS and the regulations, starts when the loan proceeds are provided to the participants, when the check is issued to them. That's when the 5-year repayment period. Some plans make the mistake of starting the 5-year period when the first payment is due. And that might be several weeks or even a month later. And then you've exceeded the 5-year requirement. So let me give an example here. In January 31st, 2017, Ben obtains a $10,000 loan with the final payment being made on February 28th, 2022. So you're beyond the 5-year period by a month. But as some people just say, it's like being just a little bit pregnant. In other words, the 5 years is an absolute requirement. So the way they would correct that is re-amortize the loan so that it is paid off by January 30th, 2017. They can apply under VCP, get this corrected. There will be no deemed distribution and no premature distribution tax. Now, one of the errors that sometimes occurs is that the participant is taking a loan, or participants take a loan and the plan document doesn't provide for it. Most plans now provide for loans, or at least the authorizing language for it. In this case, the IRS does have a correction procedure under the self-correction procedure. What you can do is correct this by simply retroactively adopting a plan amendment to provide for loans, and you can do this under the self-correction. Now, typically, when you have to adopt an amendment, the IRS requires that to be under the voluntary correction program. But in this case, the IRS is being quite generous and just allows you simply to retroactively adopt a loan provision in your plan. Now, this other thing,
Stephen,
yes, go ahead.
Tim, question on that. Let's say that you have a plan with 5 owners, and each of the 5 owners has taken out a loan, and the document said you can't take loans. Can you retroactively amend the plan to allow for loans?
I don't know of anything that prevents you from doing that. I don't recall any restriction because it's owners. I think it may be something if there is something, and maybe you know of it, but I'm not familiar with it.
Actually, it wasn't a very fair question. But as you were answering it, I actually thought of a reason why possibly you can't, and that is
okay.
The 401A4, I think it's -5 regs, timing of a plan amendment, right, where only highs benefit, but that really is just for a window. So I guess it would be okay
under the non-discrimination regulations.
Right. So on the timing of a plan amendment. So I guess it would be fine if you retroactively did it, but then didn't turn it off right away. So no non-highs.
Oh yes,
get the loan.
yes.
Right.
You couldn't. You can't just. Obviously, if there's other facts involved, if you just create a window, in other words, on Friday afternoon, so and the owners take it, and then Monday morning you take it away, so none of the non-Hileys have the opportunity to take it, then that's a non-discrimination failure.
Right. Right.
Okay. This problem I don't see as frequently as used to, but sometimes going back to owners, they will. When I see this problem, I usually see it with owners where they never fill out the paperwork. They're just, well, we'll take care of that later. They just take the loan out and never complete the paperwork or complete it out very late. The IRS could and likely would treat that as an improper distribution, and that would also be treated as a breach of fiduciary duty and failing to comply with the terms of the document, and the loan would not be considered adequately secured, so it's also a prohibited transaction that way. How would you self-correct it? Execute the documents, tighten procedures, and educate the trustee, who's likely the owner, that they can't do that. They need to complete the loan documents. Frequently, the problem with this is also they take the money out and they don't bother repaying it, so you've got the other tax issues that occur with respect to that.
Stephen,
Okay.
I've got a couple good questions here. If you'd like to take them.
Okay.
All right. So one question: what if the wrong interest rate was used to generate the amortization table?
Oh, well, that's a great question. It's not addressed under the EPCRS, but I think that the way you would correct that is, of course, re-amortize it with the correct interest rate, and the interest, assuming that you use too low of an interest rate, that you would just re-amortize it with any of the interest that was not paid would just be included as part of the re-amortization loan. That's how I would correct that. You can certainly file under VCP to get the IRS's approval on that. Alternatively, you could just do it self-correction in that case. But that's a good question. But that's how I would do it. Just re-amortize it with the correct interest rate plus any of the missed interest that wasn't paid.
Okay, great.
The audit cap. You can correct things under audit cap by that's when you get caught by the IRS using the same correction procedures that apply under VCP, but you have to negotiate with the IRS, and when the IRS calculates their sanction, they will take into account the taxes that could have been collected with respect to the deemed distribution and the premature distribution amount, but it's the exact same corrections. So one of the most common Department of Labor issue that you run into with respect to loans is the failure to deposit loan repayments on a timely basis. They're treated just like 401k deferrals as to the timing of deposit. It's as soon as it is reasonably possible to deposit the repayments or the 15th business day of the following month. Unfortunately, a lot of people thought the 15 day was a safe harbor. It is not a safe harbor. The Department of Labor generally considers it needs to be deposited within just a matter of days after the payroll date. Now, they did safe harbor for small plans. It's the 7th business day following the date those payments are withheld. What's the consequence of failing to comply with the plan asset regulations? And that's what they called. Well, it's treated as a prohibited transaction and a breach of fiduciary duty. In effect, what the Department of Labor is considering is that the loan is a prohibited loan between the plan and the employer. Now, to calculate the prohibited transaction, the IRS has got a revenue ruling that provides guidance on how you calculate the amount involved. Furthermore, of course, you have to report these late deposits on the Schedule H or I or the Form 5500 SF. Now, the DOL has its own correction procedure, which is the Voluntary Fiduciary Correction Program. Now, there's no payments in there, but you do have to apply for that. And what they and if you file under this, they will waive the breach of fiduciary excise tax at 20% plus the prohibited transaction. Well, they can eliminate the prohibited transaction tax, but what you do under this is you make up the lost earnings to the plan. Actually, it's the greater of the lost earnings or the or an interest rate under Code Section 6621. The Department of Labor has now created several years ago, created an online calculator which is based on the interest rate, the 6621 interest rate. Now, verbally, the Department of Labor has said that you only should be using the online calculator if you file under the Voluntary Correction Program, Voluntary Fiduciary Correction Program. A lot of people use it anyway because it's just easier to use. The difference, I mean, you're really supposed to, if you to use the greater of the interest rate or the lost earnings, but usually the difference is not significant, and so a lot of people just rely on the 6621 interest rate. So what they do is you deposit the late loan payments and you correct by adding the lost earnings with respect to it. And there's also a calculation of earnings on the lost earnings too. Now, you should generally try to complete this before you file the 5500 because you have to answer this question as to whether you're late, and it's best on the 5500 so you don't generate potential audit to be able to indicate, yes, we were late, but yes, we have corrected this. Now, submitting under the Voluntary Fiduciary Correction Program assures you that the DOL won't recommend you for an audit. Now, if they do come on an audit, then the DOL can assess a civil penalty for breach of fiduciary duty for 20% of the amount recovered as a result of the settlement or the litigation. So as I've already indicated, to correct this, you transfer the delinquent loan payments and then the lost earnings on the late deposit. The transaction excise tax is really not that significant, but if it carries over many years, then the tax increases. The tax is calculated on the tax. It exponentially increases with respect to it, but it's 15% of the amount involved. As I indicated, there is a revenue ruling that explains it, but it's on the lost earnings. That's what the excise tax is calculated on. Now, if you file under the Voluntary Fiduciary Correction Program, you can get a waiver of the prohibited transaction excise tax. They're trying to create an incentive for you to qualify for this waiver of the prohibited transaction excise tax. You have to, the deposits have to be made within 180 days of your payroll date. You have not taken advantage of the Voluntary Correction Program for this particular issue in the previous 3 years, and you provide a notice to the interested parties, the participants. That's what a lot of employers object to. They don't like to air their dirty laundry with respect to the employees, and so that's why a lot of people don't bother filing under the Voluntary Fiduciary Correction Program. Now, if you do and you meet these requirements, then you get a free pass on the prohibited transaction excise tax. But the excise tax is usually not that expensive, so a lot of people say, you know what, we're just going to correct it, make up the lost earnings, we'll use the online calculator so we can do it quickly, and if the DOL comes and audits, we'll just have to deal with this. But this is a way out of it. If your excise tax is less than $100, you can just deposit it with the plan and not file it with the IRS. Now, you're not required to file under the Voluntary Fiduciary Correction Program, but if you do, then you can be assured that the DOL will not visit. As I mentioned, many, at least small employers, just go ahead and correct it. Use the online calculator, pay the prohibited transaction tax, so they can indicate that they've resolved this, all these issues under 5,500, and just take the risk that they won't be audited. Just a few more quick things. I know we're out of time here. You have to use a fair market interest rate for your loan. If you don't use a fair market interest rate, then your loan is a prohibited transaction. You owe an excise tax with respect to it. So the correction would be to pay the prohibited transaction excise tax and then make certain in the future use the proper interest rate. Also, technically, if your loan, if you fail, in other words, you're not making your regular payments, or your loan exceeds the 5 years, or you don't have proper plan provisions, or it exceeds the amount of the loans, it technically also violates the Department of Labor rules, the ERISA rules, if those loan requirements are in your plan document. But as a general rule, if you correct those under VCP, then the Department of Labor considers those corrected. So as I indicated, if you correct them under VCP, you should be fine with respect to it. Okay, let me just finish up here. A lot of people have been asking me, what, Steve, you're going to do now that you're back. One of the things Tim and I have talked, and I'm in the process of writing a plan correction book for Recipedia. The format of it is going to be a lot of questions and answers and examples, because I know that that's what people are looking for. They're not planning on reading it cover to cover. They're looking for very quick answers and have them illustrated with good examples. And this is a list of the various chapters that we have so far. It's not final. There may be additional chapters or modifications to this, but these are the chapters that are going to be included with respect to it.
And we are very, very excited about that. Stephen, I just wanted to mention one thing before we conclude too, is that we did receive a lot of questions. So this is obviously a great topic. We will be having Stephen answer the questions, and we will post them to our website as we did with prior webcasts that we've done. So I know we only got to a few questions. Stephen had a lot of information to cover. So again, we'll be giving these questions to Stephen. He'll be answering them. And then you can check back at our website for the answers as well. So just wanted to mention that before you concluded. So please continue.
Okay. Well, anyway, this is a list of the chapters that I've been working on so far. As I know, when you do plan administration and you set up plans, there just seems to be a lot of issues, and what you're looking for ways in which you can correct these and do it in a cost-effective manner. Anyway, I thank you for taking time out of your day to spend some time with me talking about this. Appreciate your patience, and hopefully we answered some questions here, and I will get busy on the various written questions you submitted and provide answers to that. Again, thank you for participating in our webcast today.
Thank you.